In the course of your investigation, is there anywhere that you have identified that the Deputy President of the Republic of Kenya, who you want impeached, influenced any tender award? Thank you, Honorable Speaker.
And the senator was elected by the people of Kajiado, Senator Sek.
Thank you, Honorable Speaker. My question goes to, or clarification goes to Abdi Mohammed. Mohammed, we have realized that there is a report from the ACC and a report from the Committee of Health of the Senate in regards to the, this issue of mosquito nets. I want to confirm that the contract was cancelled and the funds were not lost. I want you to demonstrate the role of this agent by the name Crystal Kenya Limited in relations to the Deputy President's office and more so regarding Gachagua. Thank you very much.
Senator Miraj. Okay, if you don't have any question, then log out. You may now proceed, and thereafter we'll have an opportunity for the counsel for the Deputy President to respond to the clarification sought.
Thank
5
you.
minutes.
Thank
Abdi,
you,
you have 5 minutes.
Honorable Speaker. In fact, I'll take less than 5 minutes. Senator Omutata, I think he raised the issue of whether the agreement of the Kenya Kwanza document or Kenya Kwanza government document is unconstitutional. I think that one is only the courts that can actually find whether that document is unconstitutional or not. It's not within my ability or power, or rather to comment about the constitutionality or otherwise, and whether the document is null and void, and whether it contravenes certain articles of the Constitution. The second one was who is to blame for drawing unconstitutional agreements or documents. I think that is also something that can be tried in court in my view. If anybody suspects whether this document is constitutional or not, I think the best thing to do is to try it in our courts, and they will of course give directions on what can be done. Now, the other one was whether we have investigated any criminal conduct against the DP. I think I had indicated clearly that we have not investigated the Deputy President for any criminal culpability or any criminal case as far as EACC is concerned. Senator Chute, thank you very much for the compliment. I appreciate. Now, the issue of bullying of KEMSA officers or staff, I think that came from the CEO himself, and he gave evidence in this House that will be considered by the House, whether it is something that can stand the test or not. As for Terry Ramadan, we did our bit in terms of recommending this lady to be disciplinary action be taken against her for her role in this particular procurement. But because I indicated we don't have the compellence powers to enforce disciplinary or administrative action, I leave it at that. And whether our recommendation is for the impeachment of the DP, Ours was to respond to the summons that was given to us by this Honorable House. It is for the House to do, that is their job. I wouldn't want to go there. We never recommended, I don't want to go there. Then whether there was anywhere where the DP influenced any tender, no, we do not have that, and we never submitted that. All that we said is what I'm going to say in the next response, which was raised by the Honorable Senator for Kajiado County, about the role of Crystal Kenya Limited and the connection between that company and the Honorable Deputy President of the Republic of Kenya. From the documents that we have and which we supplied, it is clear that this company, the directors are two sons of the Deputy President. Each one of them owns 200 shares. They are the only directors of that particular company. And that is the nexus between the Deputy President, Honorable Rigathi Gachagua, and that particular company. And that is our response as of now. So, Honorable Speaker, thank you very much. That's it.
Counsel for the Deputy President, we'll give you 10 minutes, starting now.
Thank you very much, Honorable Speaker. I'll share my minutes with my colleague Ndegonjiro. My questions are limited to the issue of the shareholder agreements. I'll be quick. The questions were asked by my learned senior and colleague and friend, Professor Ojenda, Catherine Muma, and Senator Omtata. I'll begin with the questions by my learned senior, Mr. Ojenda, and I'll begin with the second question he asked. He asked, is the relationship between the President and the Deputy President irretrievably broken? That's not a legal question, but in my experience as a Kenyan, there is no such thing as an irretrievably broken political relationship. Members of Jubilee, a party I served as an advocate for, woke up in March 2018 to find their leader shaking hands with his opponent at Harambee House, and they subsequently found a way to work. A few months ago, the President and the Honorable former Prime Minister have found a way to work. There's no such thing as an irretrievable political relationship. Secondly, leadership constitutionally is not so much about how you feel. It is about your duty and your responsibility constitutionally. Your feelings must take a backseat to your duty to the people of Kenya. Secondly, I was asked about the counties. Now, when you look at these shareholder agreements, and again, if members will go with me to page 418, where you find the shareholder agreement between ANC, Ford Kenya, and UDA. Sorry? Oh, volume, sorry. I don't know how to increase the volume.
Council, sorry, Council. Members, I'm getting a bit lost when you say UNDA. UNDA, if spelling in Swahili is UNDA.
No, UDA, sorry, I come from Kenya.
United Democratic Alliance. If you use maybe the you first make clear.
I'm sorry.
That it is United Democratic Alliance.
Yes, I'm sorry. We use acronyms, I'm sorry. It's the United Democratic Alliance Party. The full name of Amani is Amani National Congress Party, and the full name for Ford Kenya is Ford Kenya Party. So their agreement at page 429, you will note, Professor Ojenda, it does not talk about counties. The agreements seem to have been structured in regions. It talked about region. Now, I don't know what they meant by those regions, but what I can tell you is that at paragraph 20.
Also, I will allow Mr. Habdi to have a seat somewhere as you conclude.
Yes, as I said, Honorable Senator for Kisumu, at page 429, which would be paragraph 20, subparagraph O. That's the first proviso there was. further terms, parameters, and details of the sharing of positions of responsibility in the national government pursuant to this article shall be contained in a separate schedule to this agreement, which schedule shall be negotiated and executed before the date of the general election scheduled on 9th August 2022. So this was not a final agreement. My understanding is that there were further schedules. I don't know what those schedules said. They are not available at the register of political parties. They may very well have included all the counties you asked for. Maybe Kisumu was in the subsequent schedule, I don't know. Secondly, the drafters of this, as I've said, were careful to stay within the confines of the Constitution, because at paragraph 22, subparagraph G, this is what they said. Notwithstanding the content of this article, the founding member parties hereby commit to make any adjustments that may be necessary to accommodate the development priorities of other parts of the country, to ensure equitable distribution of Kenya's national resources and wealth for the benefit of every citizen and every part of Kenya. So there was a proviso to ensure that the document was constitutional. And perhaps while I'm on that issue as well, I might as well answer my good friend on Senator Mtata's question. I am not yet mercifully a judge. I cannot say whether the Kenya Kwanza coalition is unconstitutional. Somebody will have to move the court for that determination to be made. But what I did say was that in 2005, I had the privilege in participating in a case involving the MOU for NAC. And that one was struck down because the law had no underpinning making room for it. And which brings me to the question raised by Senator Catherine Muma, which is the political parties section. There's actually not one, there's several. If you would go to Schedule 3, subparagraph C, B, D, and E. Let me read them out for you. So B deals with the policies and objectives of the coalition. That's B. D deals with organizational structure and management of the coalition, including county structures and systems and county government bodies, which you'll also find in these agreements. And then C, the overall structure of the coalition. And then E, the criteria or formula for sharing of positions in the coalition. That's what it says. Positions in the coalition structure, roles, and responsibilities within the coalition. So that's what it says. So most political coalitions have interpreted that to mean, and it's been healthy thus far. I think it's helped, in my view, this country become a bit more stable and united. And I think I've answered all those questions that had to do with the question of the shareholder agreements. Unless members had any clarification, I rest.
Thank you, Council, for DP. Council Ndegwa, you have something to pick, or do we conclude it at that?
Specific questions and clarifications. Noting at the mood of the House, perhaps I can indulge the House. I respond the same after lunchtime.
No. After lunch, we are going straight to your main witness.
Very well, Mr. Speaker, sir.
So what we can do, Council Ndegwa, allow me to invoke Standing Order 34.2A for the convenience of the House to add 5 minutes. So the House will rise at 1:05 instead of 1.
I am well guided by your wisdom.
Yeah, Mr. Speaker, sir, there were 2 questions for the National Assembly side to respond.
Okay,
2 questions.
then let's do this. Let's do this. Instead of the House rising at 1:05, we will rise at 1:15. So, Council Ndegwa, you'll take your 5 minutes, and then the rest shall be given to the Council for the National Assembly.
I am well guided, Mr.
Speaker, sir, the witness is asking if he can leave the
Absolutely.
platform.
He's discharged.
Thank you very kindly, Mr. Speaker, sir. I was asked to clarify by Senator Joyce Correll, why I am dealing with the report from the Senate, and what am I driving at. The report to the Senate is intended to indicate that none of the participants in that tendering process ever benefited from that particular process. All the 17 companies, none of them benefited, and that as a result or as a consequence of the failure to proceed to the next levels, the country did not lose even a single cent. A question was put to me why I am looking at the submissions by various parties and not going to the observations and the recommendations by the Senate. And just like a skillful legal surgeon, I have been able to point out various findings, submissions. For example, the submissions finding themselves at page 222, paragraph 107 and 106, 107 and 109 find themselves at the recommendation, at the observation of the Senate at page 271. So there is serious correlation between my findings as submitted by various parties who appeared before the Senate and the observations made by the Senate. So I dealt largely on what the Senate found as opposed to what the Senate had during the proceedings. Number two, Mr. Speaker, sir, clarification was sought as to why the bid failed, and although that will be dealt with at length, permit me to draw the attention of the Assembly to page 108 of the volume 3 of the Deputy President's Body of Documents. You'll find a letter from KEMSA dated the 5th May 2023, being a notification to Shobika Impex Private Limited. And it reads, the reference is made to the above tender and advised that the tender was unsuccessful due to the following reasons. 1, tender security was not paginated. Number 2, please plan to collect your bid security from the procurement office immediately. It may be of interest to note the date when this letter is being generated is the 5th of May. It will also be of interest to note when the alleged bullying and intimidation occurred. This letter precedes the alleged bullying, alleged intimidation. Number 2, Mr. Speaker, sir, this letter is voluntarily being issued and being generated by KEMSA themselves at their own intuition, as opposed to being triggered by any external officer, in this case, the person of the Deputy President. In their own volition, KEMSA triggers and invites Shobika to come and collect their bids, and on witness, Mr. Speaker, sir, the witness confirmed that this is always the end of a failed bid. Finally, Mr. Speaker, sir, permit me to draw the attention of the Assembly to the matter in issue. That is at page 36 of the volume 1 of the impeachment motion. The matter in issue that is subject for interrogation, Mr. Speaker,
45 seconds.
As I pen off, is not whether the tenders were responsive, whether the country lost any money, whether investigations were done, whether there was conflict of interest, whether there were gifts that accrued therefrom. The question in issue is, did the person of the Deputy President bully the officer? Was there evidence? So let us not lose ground or focus on the ground on the matter in issue, so that we focus and we put the train on rail. Thank you, Mr. Speaker, sir.
Counsel for the National Assembly, take us to the rise of the House.
Mr. Speaker, sir, how many minutes? 10? Yeah, thank you, Mr. Speaker, sir. I am here to respond on behalf of the National Assembly on only 2 questions. Mr. Speaker, sir, listening to the Deputy President's side, I believe they have misunderstood the nature and context of ground number 11. And there was a question by the Senator whether we have substantiated ground number 11 on bullying of KEMSA officials. Secondly, there was a question also on whether there was loss of public funds in this tendering process. Mr. Speaker, sir, allow me to answer the first question by mentioning that the Deputy President of the Republic of Kenya is a high-ranking state official. The Republic of Kenya, the polity of the Republic of Kenya is based on certain fundamental national values and principles of governance. In addition, there are provisions on leadership and integrity. If you look at the provisions of Article 75, starting with 73, then you conclude with 75. There is an express prohibition on conflict of interest when it comes to all state offices. Now, to contextualize that question, you have to look at the purpose of impeachment. The Deputy President, being a high-ranking state officer, means that there is a constitutional process for bringing him into account to question his conduct. And that is why you have this process of impeachment. Impeachment is about political responsibility. It's about governance. Impeachment is not about criminal culpability. It's not about gathering evidence for purpose of taking him to court. It's about bringing him to account on what he has done from a political standpoint, and that issue of the distinction of criminal processes from impeachment has been clarified by the Supreme Court of Kenya. The Supreme Court of Kenya, in the case of Mike Sonko, was expressed clear and unequivocal that impeachment is about those values, ethos in Article 10 and the provisions of leadership and integrity in Chapter 6. Now, if you look at the way ground number 11 has been coached, ground number 11, Mr. Speaker, sir, ground number 11 talks about gross misconduct. Now, the Supreme Court of Kenya has interpreted what amounts to gross violation, which in context then means gross misconduct. And the conclusion is that when you violate these core values in Article 10 and the provisions of leadership and integrity, then you are guilty of gross misconduct. You are guilty also of gross violation of the Constitution. Sometimes you are guilty of abuse of office. So to put it in context, if you look at that charge that we have put in ground number 11, it talks about bullying of KEMSA officials. Now, that fact of bullying, and we have been more specific. If you look at the charge, we have mentioned the specific clause of legislation where the act of bullying has been prohibited. And this provision, if you look at the provisions of the Leadership and Integrity Act, the provisions of the Leadership and Integrity Act specifically prohibit bullying of bullying by state officials. And in that context, then you can see that in terms of the allegation that we are making and the evidence which has been submitted before this House, especially that call which was made by the Deputy President. The call was made by the Deputy President to a KEMSA official. Why would the Deputy President be pushing the interests of a commercial, the commercial interests of a private company? That is crystal clear when you look at his own admission in his response to this allegation. The Deputy President has admitted that he lent the sum of Kenya shillings 200 million to Crystal Company to acquire some hotel in Nyeri. This is the same company which the Deputy President is making a call to KEMSA to consider. And a senior KEMSA official, in this case the managing director, goes to EACC in a tender process.
Mr. Speaker, I just want which clarification my learned colleague is responding to, because the time for submission is in the evening.
Yes, Counsel from the National Assembly.
Yes, Mr. Speaker, so I'm just concluding that it's an impeachable offense to make the link.
Very well, now conclude.
Yes, so, Mr. Speaker, sir, if you look at then the evidence which has been submitted by Dr. Mulwa, that he received a call from the Deputy President, who is a high-ranking state official, to go to EACC, and then he went to EACC to collect evidence, which EACC had gathered for purposes of submitting that tender to the Deputy President or his conduct, in this case, his son. Then what we are saying is that that act by the Deputy President then constitutes a violation of the provisions of the Leadership and Integrity Act, specifically Section 34 of the Leadership and Integrity Act, and that amounts to bullying. And to that extent, we are submitting that charge has indeed been substantiated in all its four corners. On the second question, and here again, it appears there is a misnomer. To prove an economic crime, you don't need to prove that there was loss of funds. An economic crime in this case occurs when a sitting Deputy President, in a tendering process, he makes a call, which the recipient then interprets in a different way, perhaps to influence the tendering process, or perhaps to for certain decisions to be made in favor of that person. And the person who is making the call is a sitting Deputy President. That is why then the provisions of the Constitution prohibit
Mr. Speaker, sir, if you may, I think my learned friend has enjoyed a lot of latitude in respect to responding to issues that were not sought for clarification. I was taking note of all the issues that were sought. And the issue that Council is responding to are not among those that were sought. And if they were, then he needs to indicate from which particular senator did seek that.
Counsel for National Assembly, reserve other matters for submission.
Yeah, Mr. Speaker, so I'm responding to the question of whether there was loss of funds.
That was not sought for clarification.
It was sought by a senator. And,
it was sought.
It was sought.
It was sought.
Yeah.
1 minute.
Yeah. So, Mr. Speaker, sir, in this case, evidence has been led. If you look at it from one perspective, evidence has been led by Dr. Mulwa that indeed there was a delay in this procurement. Secondly, fewer nets were supplied. Thirdly, there was a question concerning the costs incurred in this tendering process, and the evidence was that 55 million shillings was incurred in this tendering process. It came from the mouth of Dr. Mulwa. So to that extent, you can see there was some loss. Whereas the tender was financed by the Global Fund, from our own perspective, we lost a lot, not only from a monetary perspective, but also from the other factors. What about Kenyans who did not access this malaria, these mosquito nets and were exposed to malaria? Is that not a loss which is non-monetary, and therefore, to that extent, one can make a conclusion that the conduct of the Deputy President in this regard violates the provisions of Section 34 of the Leadership and Integrity Act? Mr. Speaker, so I end by stating that we have fully substantiated ground number 11, and it's one of those grounds where the evidence is clear, conspicuous, and there is a nexus to the Deputy President himself through a phone call that he made to Dr. Mulwa, and he has admitted making that phone call. Thank you.
Thank you. Now, Honorable Senators, we are going to start with the Deputy President at exactly 2:30.